Thank you so much for coming out. I'm really glad that there's such interest in this discussion tonight. I assume that everyone knows what the ACLU is, but I do want to give you our perspective and how it relates to the field of science particularly. We are been around since 1920 nationally, since 1933 in San Diego, founded by Helen Marston. Our mission is to fight for individual rights and fundamental freedoms for all people. We're no stranger to science. We probably got our first education and national reputation involving science in the 1925 Scopes monkey trial, where we argued that you shouldn't be thrown in prison for teaching evolution. People forget that that was an ACLU case, and Clarence Darrow was an ACLU cooperating attorney. And that involvement has lasted in different forms ever since then. Most recently, of course, various aspects of DNA, whether being used to exonerate people who have been falsely convicted or to restrict the gathering of DNA material by law enforcement when they arrest you, for example. The last time I was in this space, we were giving out our first ever award to high school kids for projects at the science fair that either promoted civil liberties or reduced the harm to civil liberties. Because we're trying to put on its head the notion that everyone assumes that science and technology are always bad for civil liberties. And we're getting kids and high-level scientists and technology experts in this area to think about how science and technology can be used for good. So let me tell you a little bit about this case. No one's been absolutely explicit about what this case is. On May 12th, we filed suit in the District of Columbia. We sued not only Myriad Genetics, but the U.S. Patent Office. And we had a range of clients who are scientists, who are doctors, and who are women. Our challenge is specifically to the breast cancer 1 and 2 patents. We say that the Patent Office should not have issued those. And the breast cancer 1 and 2, which people call BRCA 1 and 2 for short, are really important discoveries that a number of agencies and scientists and government funding help bring about. And if you're found with a particular variation of the BRCA 1 or 2 gene, you are very high risk for cancer, it turns out, 85% even. So it's, I don't think they've yet shown causation, but they have shown this very high level association for breast cancer. They've also shown a high level association for ovarian cancer. Myriad Genetics got the patent in 1998, and it has been worse than the average company in sharing its patent and giving access to other scientists. Whereas most companies usually see an advantage either for the general good or for profit to license out and give people broad access to do research on the gene, Myriad has been much more restrictive with it. It's also charging a very high cost for the test that they own the exclusive right to find out whether or not you have this variation that means you have a high association with breast cancer. So it costs women $3,000 to get the test. And Myriad is not contracting with all insurance companies, so it's often the case that your insurance company won't be covering that that service, and therefore you can't get it. It's problematic for another reason. This gets more to the general issue of the problem of patenting genes. It doesn't allow women to go to another company and get a second opinion. If you're contemplating that you might have breast cancer and might take steps to preventively have your breast removed or other therapies, it's the type of thing that you might want to get a second opinion about. And currently you can only go to Myriad. They have the complete control over who does the test and what the test is. So that's why the ACLU got interested. We don't take cases that are just abstract principle. We take cases that affect real people's lives. In this case, the women, the doctors, and the scientists who want to do research on this and are excessively restricted to our minds. I do want to dispel early on the notion that we are challenging the constitutional basis of patent law. We are not. We do not find that patents are unethical. We wouldn't be on that list. And though this has broader implications than BRCA 1 and 2, it really will have implications for patenting of any gene. My view is that it's a very limited challenge of patent law generally, of commercial research interests, or other research activity. So we're not challenging any medicines or therapies or tests that come out of this research, any patents on those things. In fact, we think that that's absolutely where patents should be. Patents should be on those sorts of inventions, but the product of nature itself, the gene or the gene sequence, should not be the subject of a patent. The patent system typically does a very good job of balancing the various rights at stake here, rights and interests. It sets up this limited time period under limited circumstances where you can have this monopoly. And for most of its history, it's done a very good job of striking the balance in a way that encourages science. You, in fact, encourage science by giving this limited control over limited time for these inventions. This is, however, an example where the patent system has gone off the tracks a bit. For the past 20 years, they've been granting patents on genes. And there is a theory of the law that has evolved, which says that in biotechnology, the idea that you can't patent a product of nature does not apply. So it's been said biotechnology by nature involves isolating and replicating biological materials to produce unnatural levels of purity. Therefore, the product of nature doctrine is toothless. We are challenging the patents in two ways. We're challenging on the application of patent law to begin with, not just on the constitutionality. So all the criteria that Len laid out there are aspects of our challenge. And we're also saying that because the patent law system has, for the past 20 years, failed to do its job of balancing the competing interests here, we're evoking the First Amendment and the freedom of speech clause. Why is this freedom of speech clause involved here? The freedom of speech doesn't just protect what you say on a soapbox on the corner. It protects the ideas that you are trying to express and the ideas that you have running around in your head as well. And it's extended in different parts of life to protect the act of writing, researching, and inquiring. So you actually have the First Amendment and free speech implicating a number of different areas where you might be surprised to, including in scientific research. The First Amendment free speech clause has not been used to challenge patents before, so this really is an interesting and novel application of it. One that we don't think would have been needed if the patent system had been doing its job. In terms of the constitutionality of the patent system, as was shown there, the idea of patents is written into the Constitution and itself strikes out that balance. Keep in mind, however, that the First Amendment, as the other 10 amendments and subsequent amendments, were all adopted after the Constitution was adopted and therefore modify what's in the Constitution. And so besides the balancing system that the Article 1, Section 8 sets up, the First Amendment also modifies that. Our clients in this case, I'll just give you a couple examples. Lisbeth Seriani is a single mom who was diagnosed with breast cancer in 2008. She was advised to receive the BRCA gene test to ascertain her risk of ovarian cancer, but her insurance company didn't offer to cover the tests. Myriad rebuffed the company's offer and required Ms. Seriani to pay the $3,000 fee, which she and countless other women in similar financial circumstances can't afford. It also applies to scientists, and one of our clients is Professor Haig Kazayan of the University of Pennsylvania School of Medicine. He had his work at the Genetics Diagnostic Laboratory interrupted by a cease and desist letter from Myriad Genetics. His research included a routine screen for the BRCA1 and 2 genes, something which Myriad's patent currently protects. Dr. Kazayan had to abruptly stop his scientific inquiry as a result of Myriad's actions. It's really important to emphasize just how broad these patents are. It's not just on the gene itself, but on anything that derives from the gene, including other tests and medicines, as well as other variations of the gene that come out of that. Any future mutations or therapies as well. So this is a broad patent, as many of them are, and the challenge reflects both Myriad's status as a bad actor in this field, but getting back to the issue of patenting genes generally, there is there's a worthwhile debate here that I'd like to hope that we focus on a bit. I think there are valid arguments on both sides. The ACLU San Diego is not the lawyer for this case. Our national office brought it. So I haven't talked extensively with our attorneys, our national office, and I think that I can be a participant in the debate on this, as well as an advocate for the ACLU's position. But I think the crux of the issue is that when you take the gene that Myriad patented was in fact a purified, so-called purified form of the gene. It wasn't exactly as it's found in the body. What they did is they took it out and they removed the introns, the so-called junk DNA, which some would dispute is in fact junk DNA, and they patented that reduced form of it. So the argument, I think, is validly made that this isn't a product of nature, this has been altered or purified. And so if you buy that argument, then you might agree that there should be a patent allowed for this genetic sequence. You might not even call it a gene. But there's another side of the story, which is the view that the ACLU holds, and that is that it doesn't matter if you merely purify it, and the term purify should not be a magic word that allows a patent to be issued. It matters what the thing is, how close it is to nature, and what it does. So in this case, we would argue informationally and substantively, it is still the same thing. There hasn't been any argument asserted that what they have is something different, or that the removal of which junk DNA or introns that they used makes it somehow particularly special. They are patenting what we know and understand in the full realm of knowledge and understanding is the gene itself. And that's what we say is too close to being a product of nature to deserve a patent. We hope ultimately that the Supreme Court will bring back the right balance, either through an interpretation of patent law or in applying the First Amendment. And to quote our National Executive Director, knowledge about our own bodies and the ability to make decisions about our health care are some of our most personal and fundamental rights. The government should not be granting private entities control over something as personal and basic to who we are as our genes. This stems not only from a strong commitment to free speech in the First Amendment, but from the general common sense that's embodied in, I think, your understanding, and when asked the questions earlier and in the title of this topic tonight, who owns our genes? You ask most people and they say it doesn't make any sense that someone would have a patent on our genes. Now, people who have been in biotechnology community longer will say, well, look, there's lots of live things that and the sort of common sense approach to this doesn't make sense. But in essence, another aspect of the civil liberties aspect of this case is that we are allowing the government to either metaphorically or actually go into our bodies, invade our bodily privacy, and give control over that part of the body to someone else. And so, besides the free speech concerns, there's also a bodily privacy concern here. I will end there so as to allow more times for questions and discussions after. Thank you.